Good morning. Are you Caprina Swan?
Yes, ma'am.
And Ms. Swan, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Swan, in cause number 24, DCCR 1362, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024, and that was for the offense of aggravated robbery, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed for the months of January, February, and March of 2025. And is that true or not true? True or not? Listen to the question. Okay, true. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you admitted to using cocaine and alcohol on January 7th of 2025. And is that true or not true? Count 3 alleges that you failed to participate in the mental health services and follow all recommendations of that. Is that true or not true? Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true?
True.
And then count 7 alleges that you're behind in your court-assessed fees. And is that true or not true? All right, did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But it's my understanding that the probation department and the state are willing to give you a chance today to go to the special needs SafeP program, which will help you hopefully get all of these issues behind you, learn how to make better decisions, stop using drugs, get the mental health treatment you need so that you can be successful on this probation. I want to make sure you understand that this is your second chance now, and you will not get a third. You are on probation for a first-degree felony. Today, right now, I could send you to prison for the rest of your life. The rest of your life, from 5 years up to 50, 60, 70, the rest of your life for violating probation on this type of offense. So you need to take advantage of everything that they teach you, because when you get out of SafeP, you'll have aftercare, you'll have people to help you, find places to live and all of that. But it's going to be up to you to take advantage of those things. Do you understand?
Yes, ma'am.
All right. I'm also going to, because you didn't report and because this is going to take some time, I'm also going to extend your probation for a period of 2 years. So you're now on a 7-year probation instead of a 5-year probation. Now, every single person who's on probation in my court and any court can get off their probations early if they do everything they're supposed to. So it doesn't have to be 7 years, but it would take you getting everything in line real quick and doing everything right. Do you understand?
Yes, ma'am.
All right, good luck to you, ma'am. You can go back with the bailiff. They're going to get some paperwork for you to sign about safety. You need to
Good.
sign that when they come. Good morning. Are you Michaelan Jones?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your,
I'm sorry, just
Oh, that's okay.
we're only going to count 2, 3, and 4 whenever you get to it.
thank you.
That is correct. Thank you, Mr.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point Coupe in Louisiana. And is that true or not true?
Yes, ma'am.
True or not true? Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
And then count 4 alleges that you committed the offense of possession of a Schedule I drug on May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Did not.
And did you plead true to those counts because they're actually true?
Did not.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Did not.
Do you fully understand them?
Did not.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Did not.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily.
And there it is, probation revoked and 21 months behind bars. But here's the twist. He gets credit for time already served. This is a classic example of how timing, custody, and legal agreements can affect a sentence. It's not just about the crime, it's also about the process. Imagine sitting in court knowing every day counts. The tension here is real.
Voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Judge, if I may, the motion was filed in June of 2023 based on offenses that happened in May of 2023. He's been in Louisiana custody since those offense dates of May of.
Notice the judge's strategy here. Instead of retroactively applying the sentence to the offense date, they start credit from the motion filing. It's cleaner, legally precise, and shows how courtroom technicalities can significantly impact outcomes. Legal detail or loophole.
Of May of 2023. However, our hold for this motion to revoke didn't get placed on him until October 7th of 2024.
And Judge, Mr. Rojas, I'm sorry to interrupt, Mr. Rojas, and I have conferred, the state is not opposed to the court giving the defendant the credit for the time he's been in jail while this case is pending. You may recall, I've researched the issue. I actually briefed it and I gave the court that authority.
You did.
I think you have that authority if you choose to award him that credit.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion,
Okay.
which is just a month or so
Right.
or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, but there wasn't a hold place for some reason.
Correct.
And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will, we'll get that done. Okay?
Thank you, Judge.
All right, so Mr. Jones, I am handing you the trial court certification, well, 2 things. One, showing that this was an agreement, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and thank you, probation, for being here as well.